Because all we are trying to do is to secure the what? The treasury from the ravages of what we have seen so far. But the basic issue is that even if you do that without the basic machinery, I have always said that we have more of administrative problem in this country than what we are looking at through the political or legal means. Basically, the chief executive of the state is not the accountant general of the state or the federation. But how come that we have seen trillions or billions moved and nobody has asked questions? Now there is no audit of any of our proceedings for the past 8 years. In some of the parastatals, you ran 8 or 10 years without an audit. And then even if the internal and external audits are not really in conformity with our Fiscal Responsibility Act, by the provision of Fiscal Responsibility Act, every person is accountable. If you go and take a good look at that act, it was from the Organization of Economic Coordinating Development Countries, who now felt that you should bring in a dynamic legislation that will make you accountable through transparency and accountability. What have we done with this since 2007 up to date? Both at the federal and the state levels, we have not been able to make anything out of it. So what I am saying is that you can amend the Constitution, but after amending the Constitution, if you have no will, you have no activism, and if you have no knowledge, because ignorance is even at the root of what I'm doing, and then when you have no legislative and legal framework to be able to bring any person to book and then creditably solve the problem through court process, then you will be wasting your time. We will be merely spitting in the wind. That is my submission.
So what do you think that the House of Representatives should have done in this case, rather than amend the Constitution to remove this immunity?
Well, you see, it is not a matter. The House of Representatives is a part of the National Assembly. And you remember that the House of Representatives, just like the Senate, went and conducted public hearing and the rest, thinking that that will be their own legitimacy strength in our public participation. But what I feel is this: we are overburdening the National Assembly by carrying most of these issues to them. I had expected professional bodies, Nigerian Bar Association #1, Political Science Association, Historical Association, Nigerian Union of Journalists, and the rest of them, who would have been able to bring the public notice and awareness over what we are doing. If the public has gone on debate and the enlightenment process, by now most of these things will be addressed. But you see that we are all failing at the same time through our civic duties, and then now we now throw it back to the National Assembly. Like I have said, the National Assembly, you have seen them vote according to their conscience and their political leaning. Nobody can take away that from them. But if we have had the robust and serious commitment to constitutional amendment by the participation of all and sundry, by now we will have seen this is the drive. The first amendment succeeded, remembered, was giving INEC an independent or financial autonomy. That succeeded because the challenges of 2007 election was such that even the late President Yaradua admitted to the world that the process that brought him to power was mad with electoral malpractices. And then we were not convinced that even the tribunals, the electoral tribunals, were able to do justice to that. So based on that necessity, more or less, the constitutional amendment sailed through based on that spirit, that we will be able to correct the problems associated with electoral process, and then now bring somebody on board, bring a new chapter on board. At this issue of immunity, such level of commitment, such level of public agitation and contribution, dynamic and robust constitutional challenges and contributions that would have elevated this to be a national issue was lacking, and that was why we are where we are at the moment.
But with respect to granting the local government's autonomy, I mean, we'll have lawyers who think that this goes against the principle of true federalism, that you cannot ask or scrap the grant them local government autonomy, which some state governors virtually or just literally kicked against. They say you'll be creating more problem than you can solve.
Well, democracy accommodates all, basically. That is why we say that it is the majority. Like somebody like Alexander Paul called democracy a madness of the many for the benefit of the few. So all of us have our different ideologies over our leanings or understanding. But let me tell you that the Constitution, if you go to Section 7, the Constitution on its own guaranteed independence and democratically elected local government on its own. It is not the state that guaranteed. Let me make this clear. And if you go to Section 3.6, you will see that the local government is a part of the federation, and a full share of Schedule 4 was committed to local government. And in the decided cases, led first by the Second Republic case of Ejidonwu and Governor of Bende State, it is clear and explicit that local government is an independent unit of its own. What we have now is that Section 162, subsection 4, placed local government funds into a joint account of the state, just like the issue we are talking about, the immunities. Now, the state governments have abused this, and having abused this, by now converting the funds made for local government, which would have been shared actually. And I blame the local government chairman, but because of the political contraction or political handicap which they found themselves, because they are handpicked more or less by the ruling state governors who are now zealous on their own, they cannot do anything while they have seen their fund going into what? Into the pockets of the chief executives. I am from Anambra State. We are from 1999. Apart from the 1999 local government election had not been held for local government, yet the Constitution guaranteed democratically elected local government. So the issue is this: the local government is autonomous by constitutional provision, but the manipulation of the state government in taking their funds had not been addressed, because we are all guilty of this, because we have allowed them to do what? To corner the funds made for local government. So local government by the Constitution is autonomous. The Constitution guarantees that, and there are decided cases to do that. And I have told you that even in the interpretation clause of the Constitution, if you go to the interpretation clause, local government is included there. So there is no way that we will look at local government having failed in our own constitutional duties as watchdogs. That's why I'm still calling Nigerian Bar Association and the rest of us who have allowed this impunity to go on. And now, what I am saying is this: do we need to make another law to talk on constitutional or democratic existence of local government? So go to Section 7. It is settled and tried that this is an independent and autonomous entity or tier of government. 774 local government and 6 area councils is ordained even in the schedule of the Constitution. So there is no argument on this. But what we are saying that if the force of local government is now cornered by the state, that if you take a good look at the provision or proposal towards that amendment, if you stop giving funds to any local government that is not democratically elected, the Constitution will back you. But we have not been able to have the guts. And I have said that repeatedly, that Anambra State and the other states in the Constitution, and look at the governor of Anambra State, who himself is a beneficiary of the judicial and democratic elected government, is now a victim after ruling Anambra State for 8 years. There is no local government election, and all of us have kept quiet. So what we are saying is that, like I have said it initially in my entry, that Constitution will not solve all problems directly. We need to be on our own. The American Constitution is 237 years old. It has only 27 amendments. The right for the blacks to vote in America did not come through the Constitution. It was Lyndon Johnson and Kennedy's enactment that led to that. After all, even the women were not voting until the 60s in America. So these are the issues we must look back at and then be able, on our own as committed Democrats, to bring the Constitution to life, rather than all this pedestrian distraction of consistent and endless amendment processes. That is my take.
You know, when you talk about all of this, now it brings to mind the talk about immunity and impunity. We'll go back to it again, because if you look at it now critically, looking at the Constitution, I think a whole lot of review is as a result of